Good afternoon, everybody. Thank you for indulging us and doing the Zoom. So my name is Allison Shames, and this is Matt Alsdorf. We are both employees of the Center for Effective Public Policy. We have had the pleasure of working in 2021 when we started to work with the Supreme Court's pretrial task force that was then tasked with implementation. We spent the good part of 2022 working with the statewide task force on preparing for implementation of the PFA, educating counties around the state, educating stakeholders, providing some technical assistance to a few sites, and preparing resources that many of you have probably seen that are available through AOIC's website. So what we're going to do today is talk a little bit, and since that time, since the PFA went into effect, we have continued to be involved with Illinois. We've been talking with a lot of stakeholders in the state, trying to understand how the implementation is going. So we're not doing the research. We benefit from Dave and Don's research, but we've been doing a lot of conversations, a lot of looking at the data, trying to make sense of it, and trying to see how the system is operating in this new way. And so I want to start very quickly by, I'm going to share my screen, and I want to start just by making sure everyone understands how the PFA is working. And this might be repetitive for you, but we're going to, hopefully clarify some things, or maybe shed some light on a few of the pieces of the legislation and how it works in practice. So very briefly, and I'm going to keep this up as I talk about how the law works, because I think what Dave shared with all of the data is absolutely essential. But I think what this review of the law is going to show too is that we don't have data for a lot of pieces as well, which would really help understand how the system is operating. And that really starts at the very beginning, is that one of the things that the Pretrial Fairness Act did was obviously limited the use of money bond, as Dave said, the biggest part of the changes. But it also expanded and allowed for greater use of citations or summons to appear before the first appearance hearing. And that sometimes doesn't get looked at. But when you get rid of all of those cases, it also means that the more serious cases are the ones going to that first appearance hearing. Those are numbers, some of the counties are tracking it, Cook County's dashboards do, but not all of them do. But that was an important part of the law as well, that first part, right when the law enforcement stops you, as well as when they go and book you into their precinct jail, you can be released by them immediately, not by the payment of bond, but because they use their discretion on lower level offenses and release you on a summons to appear. If you are arrested, charged, and booked, obviously, then you will have a first appearance hearing. That hearing will either be a detention hearing if the prosecutor petitions to detain, or it will be a release hearing, a release conditions hearing, if it's not eligible for detention, or if the petition to detain is not filed. That obviously was a very, very big difference. And one of the big things it does was it provides due process. And Matt will talk a little bit more about that at both the detention hearing and the release conditions hearing. So Dave talked about the longer hearings for the detention hearings. We understand that the hearings for the release conditions, those are also lasting longer than normal. They're not going to be as long as the detention hearing, but there is still a finding by the judge to determine what are the most relevant conditions to be imposed on someone, making sure that they are the least restrictive conditions. Judges are required to use individualized and least restrictive release conditions. I also just want to note, as Dave said, that only specific offenses are eligible for pretrial detention. And to be detained, a state's attorney has to file that petition to detain. And it is only certain offenses, as I said. So for public safety, and you probably have the list, but we're not talking about any non-serious. Most of those offenses that are eligible are violent. As Dave mentioned, I want to highlight that as well, which is a lot of them are DV related. So I think what this is also showing us is that we have to look closer at those DV cases, as judges are. I think I also want to point out that one of the biggest differences with the PFA is that judges have to put their reasons on the record, and they have to find. Before, they were just setting a monetary bond. They didn't have to put anything on the record about that amount. What they have to do now to detain someone, they have to state on the record that the proof is evident, or the presumption great, that the person committed an eligible offense, that the person poses a real and present threat to the safety of a person or the community, based on the specific facts of the case. So we're not having arbitrary decisions. We're having the prosecutors and defense lawyers really are like talking and presenting to the judge the evidence for and against detention. And the judge also has to find that no condition or combination of conditions can mitigate the threat that they see. So there's a real showing that the judges have to make, and that accounts for the longer hearings. I want to also just talk a little bit about something that we don't talk a lot about when we talk about the PFA. And that is what happens to people when they are put on pretrial release, but they fail to comply with one or more conditions of release. That failure to comply can be a failure to appear, or a new criminal offense during the pretrial period. I think it's important to point out here, again, we don't have any data yet. We don't see it being collected in great numbers. I think this is another area to explore. What we know is that most people are going to succeed and comply with all conditions. But if they don't, there are a number of different options now for judges. They don't just move to revocation. They can issue a summons or warrant to ensure the person's appearance in court. And so when we're talking about those FTA numbers, judges are encouraged now under the PFA to initially respond to violations with summons to appear, not to immediately move to an arrest warrant. We haven't seen the data yet on that. That's an important one to look at. Once they come to court, the court has many options. They can modify the conditions of release, meaning they can increase the conditions. Maybe they weren't on pretrial supervision, and now they can be on pretrial supervision. They can also order sanctions that range from a verbal reprimand to even putting someone in jail for up to 30 days. Again, we haven't seen the data on this. Sanctions are also only allowed if the noncompliance is willful and not due to financial hardship. And lastly, the court may revoke pretrial release, but that is also limited to if the person is charged with, it's only for reoffending, and only if they're charged initially for a felony or Class A, and they get charged again with another felony or Class A, or if their person is charged with a violation of an order of protection. These are areas that we think data really is important to look at more, and we'll be looking forward to more data collected by Dave and Don, of course. What we're seeing all around, and I'm going to stop sharing now, so we'll just go back to us, is that the PFA is really effective, as we heard from the data all around. I want to start by saying that what we see from that data, and reiterate something that Dave said, which is everyone is exercising their discretion. This was the big fear, right? The big fear was that everybody would be petitioned to be detained, and that the judge would be granting every person who was petitioned. So there was a fear on one side that everyone would be detained. There was a fear on the other side that no one would be detained and the jail doors would open. What we're seeing is that people are exercising their discretion, as they should be doing. They are making intentional decisions. Prosecutors are not asking for detention on every eligible case, and judges are not ordering it on every motion. Defense lawyers are also not filing an appeal in every case now that some of those rules have changed. This is true in New Jersey as well. As you all probably know, New Jersey is our jurisdiction that we go to as another example of a system that has gotten rid of money for the most part, and is in a similar way that they have an intentional process. We're seeing a very similar pattern. In New Jersey, for those brought into custody upon arrest, prosecutors are filing detention petitions for around 40% of the cases. I think it's a little higher in Illinois right now, but again, as Dave said, variation across counties. Of those filed, judges in New Jersey are granting the petition in about 60% of the cases. That's going to be similar to your numbers as well. But that wide variance is important. And I think it's not only because, as Dave said, that they're seeing that it's going to take time and they don't have the time for these hearings. I think what we have to recognize is that every county is different. They have different values. They have different circumstances of the cases that come in, and the seriousness of their crimes are very different. So we're going to see a natural variation no matter what. We are looking forward to digging into the data more with Dave and Don to understand those variations, to talk to sites, to talk to counties about what explains those variations, and try to make sure that the law is being consistently applied across the state. Turn it over to Matt.
Great, thanks, Allison. Good to be with you all. So since the PFA went into effect about a year ago, we at CEPP have spoken with dozens of system stakeholders, so judges, prosecutors, defenders, law enforcement, pretrial services supervisors, as well as some community advocates and stakeholders to get their perspective on how the PFA is going so far. And we wanted to share a few takeaways from those conversations with you. So I'll start with perhaps the most obvious one, but the one that bears repeating, which is that money bond is not necessary. If there's one lesson that we think other jurisdictions can take from Illinois, it's that money bond is not needed in a pretrial system, and that in fact, a pretrial system is better off without it. We know from tons of research that there's just no evidence that money bond does its intended purpose, no evidence it helps people return to court or stay out of trouble with the law. What we do know is that it keeps people in jail needlessly simply because they're poor, while allowing people who pose higher risks to pay their way out. And so those are the reasons that Illinois saw fit to move its system away from the use of money and in fact eliminate it entirely. And what's interesting is now that we're a year in, you really don't see almost anyone advocating for a return to the old system. There may be people who have preferences that would be slightly different with respect to the law or with respect to the decisions that judges and prosecutors are making under the law. But essentially, no one is advocating for a return to a money-based system, even people who had been opposed to the Pretrial Fairness Act before it went into effect. And fundamentally, I think this is because system stakeholders understand that having judges make these intentional decisions based on evidence and based on the law is better than having them gamble with money. So I think everyone sees that this is a better model, and I want to drill down on a couple reasons that people identify for this being a better model. First is kind of the legal one, which is that Illinois' new system under the PFA really is grounded in fundamental U.S. constitutional principles in ways that the previous system, and in fact the status quo system across much of the U.S. right now, has become kind of untethered from. So the U.S. Supreme Court, under the Due Process Clause, has held that in our society, liberty is supposed to be the norm, and detention before trial or without trial should be the carefully limited exception. And the PFA makes good on that promise by setting forth clear standards for eligibility for detention, and then the process by which and the burden that the state must bear in order for detention to in fact be ordered. Before the PFA, these decisions weren't even directly made, and to the extent they were made at all through the setting of money, they were made with very little information, as you heard from Dave's data, with very little time. They were made quite quickly. And what we've heard from judges and others is that it's actually very satisfying for them to be making these decisions now based on legal criteria, based on evidence from both sides, just like they make every other decision in a criminal case or even in a civil case. And so they're able to bring to bear their expertise in the law and apply it to the facts before them, which is really what they do, and to talk directly about the issue. Should this person be detained or released, and why? As opposed to talking around the issue by debating how much money this person should pay to get out of court. That way, they're able to elevate everyone's concerns about fairness and public safety. one thing I will acknowledge in these conversations that people have brought up is when detention hearings and conditions hearings take longer, more resources are needed to staff those hearings. But everyone recognizes that the benefits of those hearings, they are now being done in a way that's commensurate with their importance, right? That those hearings do in fact need to be longer, but that does create some challenges from a resource perspective that a lot of counties are currently working through with some success. The second way in which this system we've heard is better is in protecting public safety. And that really has two parts. One is that there is now a clear and defined way to identify and talk about and argue over who in fact is a sufficient risk to public safety that it is necessary to detain them. But there's a second part, and it's equally important, which is that we are no longer detaining people who don't need to be detained before trial. Unnecessary detention has very well proven negative impacts, not just for the person, not just for the court system, but for public safety. When you destabilize someone's life through even just a few days in jail, they're more likely to fail to appear for court. They're more likely to reoffend in both the short and long term. So with respect to the first category, even people who, and we've heard these exact words a number of times in these conversations, even people who were opposed to the PFA say, well, the sky didn't fall, right? Some of the more exaggerated predictions of people being let out of jail just didn't, dangerous people being let out of jail just didn't come to pass. And what we've heard is generally that stakeholders feel that there is now a process and that they are able to detain the people who they believe do pose significant threats to public safety. And there's a good process of safeguards around the production of evidence, the burden the state bears, and then the discretion of the judge to determine who is actually detained. And again, the second part is we are no longer accidentally, unintentionally detaining people who simply can't afford a low bond amount. And that is very likely, based on the research, to have long-term positive impacts on public safety and community stability. I'll pass it back to Allison for a few more thoughts.
Sure, and I want to just add one more thing to the public safety, and this is something we have heard from folks who work for survivors and victim representatives, that the system now not only will make sure, obviously, all those DV cases are eligible for detention, and we are seeing in jurisdictions that those are being detained when necessary. Something else that many people do not consider is that many women who get arrested on violent charges are oftentimes defending themselves in an abusive relationship. Those women who get caught into the criminal justice system, in the previous system, they were being held on unaffordable money bond. What is happening now, and again, hearing this directly from victim representatives and victims themselves, is that the judge will hear their case if there is a petition to detain and understand their circumstances and often not detain them. So that is a category of people that are no longer being detained that this legislation was meant to protect. And it is protecting them in that way, as well as making sure that the people who are their alleged abusers are detained, not because of money, which was very uncertain, but because a judge is deciding that this is a dangerous case. So I just wanted to elevate that as a public safety issue. I think the last point we want to make here is that something that this system is elevating across the state as well is that there really is a need in Illinois and across the country. We work across the country on pretrial issues, that people are going to continue cycling through the system with really elevated needs. There are a lot of needs. We were just at a pretrial conference. There was a question to the room: how many people are working with clients with mental health issues? Half the room raises their hand. Substance use disorder, half the room raises their hand. Issues of unhoused people, again, multiple hands. These are issues that are chronic across our country. These are also the people that in the previous system used in Illinois were continuously getting caught in jail and being detained. They now, for the most part, are not committing offenses or not being arrested for offenses that are eligible for detention. And so this elevates a need to address those needs that they have. That what was happening before is they'd go to jail for a few days and then get out and then still have the problems, right? Nothing was being addressed in jail. That is sometimes a myth that people feel that they're going to get the services in jail. That is often not the case, and people are often worse off when they get out, when they have those needs. What needs, and so something that really is this coming to light is that there needs to be in place resources that can help people with those low-level offenses that will not be going and getting detained. They continue to cycle in and out of the system. And so this becomes an opportunity to identify them and address their needs and try to get that cycle to stop. I think, Matt, were you going to add a little bit more to that?
Just add slightly more to that. I mean, the question really is, you have this population or these populations that tend to cycle in and out of the system. What is the way to break that cycle? And we have not had to confront that question head on previously because people were caught in the system for a few days and it seemed like the problem was solved temporarily. But as Allison said, they'd get out and come back in. And now the fact that they can't be detained in large part for a few days just elevates the fact that we need a new approach to figure out what will help people desist from the behavior that they're being arrested for, right? That is kind of the long-term objective here. How do we break that cycle and have them desist from criminal behavior? And so that's what the promise of supportive services is. Even in the pretrial space, you may just connect them to those services. Their pretrial phase likely will not last long enough to complete treatment, for example. But you can connect people to those services they need so that in the long run, we're actually addressing those needs. And I think when I talk to sheriffs when I visit local jurisdictions who run the jail, and they acknowledge, look, I've got people in this jail, and I know this is not a long-term solution. I know we have to deal with them now, release them, and they're going to come back. We need something else. And this really, I think the PFA puts a spotlight on that need and the promise of a better solution.
Yeah, and I think one last point just to hammer that in, because we do hear people, complaining that they can't detain that person. And what we would suggest is that rather than being frustrated at not being able to detain them, that you ask them, what do you need to desist from criminal behavior? Maybe not with using that language exactly, but you all understand what we mean, which is talk to that person. And this is the role of pretrial services. OSPS is providing these services, as are the other pretrial agencies. And the important thing there is to speak to that person, as a human being, see them, hear them, understand what they need to get out of the worst situation that they have fallen into. That's what they need. They need to be connected to some services. And that really is the promise of statewide pretrial services as well. And I think we will end it there for you all to stay on time.
In terms of your recommendation at the end, in this coordination of services, is there any mechanism for that, either in the law, or there are obviously so many organizations that are devoting resources and research to this? Is there a program to work on that at all?
Matt might be able to speak to this as well. I think that was part of the law that was passed. I think it's the Pretrial Integrity Act that devotes more resources to community services. It's the role of organizations like TASC, and really it's about connecting. So nothing in the law per se, but it is the practice of OSPS as well as pretrial agencies. And that's why judges are encouraged not to move so quickly to revocation or sanctions. I think there's a real push in the law and an encouragement for the judges and really everyone around these issues of non-compliance to think about, before I put them back in, before I revoke them to jail, what are some other things we can do? And some of those things may be, again, starting without pretrial services, and now putting them on pretrial services, that creates the relationship to provide a handoff to services that task and other community supervision, community organizations are providing. One of the things we recommend to jurisdictions with pretrial services is that they sit down and just inventory all of the resources available in their local community. Having pretrial officers with that long list of resources is like an initial first step that unfortunately a lot of people don't even take. And so that would be something to look at, is making sure, again, that community organizations have the resources. As Matt flagged, more resources are needed to make this a success, and making sure that they are connected with pretrial services that can provide them with those referrals and that soft handoff. None of these services, we should say, they absolutely do not recommend that any of these services are court ordered. These should all be offered to the people voluntarily. People who are ordered services will often fail. We don't want to set people up for failure. We want to set them up to succeed. And so offering them, again, treating them as humans, understanding their needs, and connecting them to services with a warm handoff. That's really the way to go.
And the law, by the way, that Allison referred to at the early on in her remarks is the Pretrial Success Act.
Oh, thank you.
I believe that you mentioned that more data is needed on sanctions and revocation of pretrial release. And then I think you said something else that you were waiting for more information and data on. Could you clarify that, and anything in terms of target dates for having the information that's needed to learn more about revocation of release?
Yeah, I mean, I think there's a lot of areas. I think one of them was the percentage of people who are being cited and released or receiving a summons to appear rather than being brought into custody or being released before the first appearance hearing. I think I mentioned Cook County is collecting that data, but more the localities are going to need to be, I think there's some more education that's needed at the local levels so that counties outside of Cook County understand the data that they should be collecting. It's only by collecting this data that they're going to understand how their system is working. And then they're able to figure out what are the solutions, what are the changes we need to make in order to get better outcomes. So I think what you see is that a lot of them are, looking at what are the arrests, as Dave said, what are the petitions, what the percentage that are getting a petition, the percentage that are being detained, but we're not seeing at the front end if they're being cited and released. And we're not seeing after they're released, whether they are being brought before the court again for revocation, if the court is ordering sanctions, what those sanctions are, or if the court is modifying the conditions of release. And as Dave mentioned, some of this is because cases are ongoing, so the data might not be as much right now, but our hope is that localities, again, can become better educated about the importance of this data, and then to track it more consistently and reliably.